presentándonos. Bueno, ya tercero y último bloque, con la presencia del autor que hemos discutido durante la tarde de hoy, el profesor Solum, de la Universidad Georgetown de Washington. Muchas gracias por estar aquí, profesor Solum. Así que le voy a dar la palabra primero al profesor Solum, que va a hablar 30 minutos, y después le vamos a dar la palabra al profesor Gargarela de la Universidad de Buenos Aires, y después, el tiempo que nos quede, discutiremos tanto con el profesor Solum como el profesor Gargarela. El profesor Solum tiene la palabra.
Yes, thank you very much. It's an honor to be here. Thanks to all of you for attending the lecture. So my remarks tonight are about originalism as a constitutional theory. I will primarily be talking about originalism in the context of the United States Constitution, but I will also endeavor to make some remarks about the application of originalist constitutional theory to the context of Argentina. So let me begin just by making some brief remarks about the history of constitutional originalism in the United States. The idea that constitutional practice must be faithful to the original meaning of the constitutional text is a very old idea. It goes back to the beginning of American constitutional practice. But the word originalism was not introduced into the vocabulary of constitutional theory until 1980. That was the product of history, of a constitutional practice that had begun during the New Deal period, during the presidency of Franklin Delano Roosevelt, to diverge in significant ways from original meaning. And this divergence continued in the period of the Warren Court and its immediate successor, the Burger Court. During that period in American history, many critics of the court were disturbed by the failure of the Supreme Court to conform its decisions to the constitutional text. That gave rise to criticisms of originalism, criticisms of the idea that the practice of the court should conform to the text. And those criticisms, in turn, prompted the emergence of originalist constitutional theory, a process that really began in earnest in the mid-1980s and continues to this day. So I'm going to talk about 4 ideas that are associated with constitutional originalism in the United States. So the first idea is the Fixation Thesis. And the idea of the Fixation Thesis is that the meaning of the Constitution, the linguistic meaning in context, or to be even more precise, the communicative content of the constitutional text is fixed at the time each provision is framed and ratified. So this thesis becomes important because language changes, because the meaning of words change over time. For example, Article 4 of the United States Constitution authorizes intervention by the national government to assist the state governments in the event of domestic violence. So the phrase domestic violence today is ordinarily understood to apply to violence within a family, elder abuse, child abuse, spouse abuse. But that was not the meaning of domestic violence in 1787 when the United States Constitution was written. At that time, domestic violence meant riots, insurrections, or rebellions within a state. So if we want to know what Article 4 of the Constitution means, we ought to look to linguistic practice in 1787. The accident of linguistic change, the accident of what sometimes is called semantic shift, should not change the meaning of the Constitution. Likewise, meaning depends in part on context. Constitutions are not fully explicit. The meaning of many constitutional provisions depends on an understanding of the context in which the constitutional text was written and the whole context of the text, that is, the relationship of some provisions to other provisions. For example, the United States Constitution contains clauses that are written in such a way that if they were read literally, they would apply to the whole world. So the ex post facto clauses of the United States Constitution, if read literally, would apply to the Republic of Argentina. But this is obviously absurd. Any reader of the Constitution would grasp implicit communicative content, implicit content of the Constitution that is not stated explicitly. And so an example of that is that for many constitutional provisions, we would understand that implicitly the constitutional text says in the United States, not in the entire universe or all over the world. So the fixation thesis is the first idea. This idea is a common sense idea. It's based on the way that scientists of linguistics and philosophers of language understand the process of communication in general. It should not be controversial. The second idea is the constraint principle. The constraint principle says that constitutional actors, for example, the judges on the Supreme Court, or the president, or the members of Congress, should adopt an attitude of fidelity to the Constitution, that constitutional actors should obey the Constitution. More particularly, the constraint principle asserts that constitutional practice, including decisions by courts, should be consistent with the original meaning of the text, consistency, and fairly derivable from the meaning of the text. The idea of fair derivability reflects the fact that any constitution will require implementing rules or precisifications. We need constitutional doctrines to implement the provisions of the constitutional text. Such doctrines will not be identical to the text. They must be consistent with the text, and they must be fairly derivable from the text. That is, they must not be made up. The court, for example, should not have an authority simply to add new provisions to the text in the form of doctrines that are not fairly traceable to the text. So the fixation thesis aims to describe facts about the world. The constraint principle is normative. And in my opinion, it is best justified by arguments of moral philosophy or political philosophy. And I can't state the whole argument for the constraint principle here, but I will give you two examples of arguments for the constraint principle. So, the first set of arguments for the constraint principle is based on the rule of law. The idea of the rule of law as a political value. So the core idea here is that constraint by the constitutional text better realizes the rule of law than does the alternative, than does the idea of courts and other constitutional actors who are not constrained by the constitutional text. Obviously, constraint contributes to the rule of law values of stability of law, predictability of law, and even-handedness of law. But the rule of law justification for the constraint principle is also provided by the effects that non-originalist interpretation, that living constitutionalist interpretation creates within a political system. So if political actors, if in the United States the president and senators come to realize that the Supreme Court is not actually following the Constitution, but instead that members of the Supreme Court consider themselves free to translate their moral beliefs, their political ideology into constitutional law, then the President and the Senate will take that into account. Essentially, they will come to realize that the Supreme Court has become a kind of super legislature. A very important legislature, since the decisions of the Supreme Court can invalidate the actions of Congress and the President. Under those circumstances, a process of appointing Supreme Court justices is likely to become politicized. And in fact, this has happened in the United States over the course of the last 30 years. So now in the United States, there are intense political battles, intense political conflicts about who will serve on the Supreme Court. These conflicts go back quite a ways, back to the defeat of Robert Bork's nomination to be on the Supreme Court. And since that time, there has been what I refer to as a downward spiral of politicization, with which each stage in this battle becoming more intense than the prior stage. So, for example, in the last year of Barack Obama's presidency, his nominee for the court, Merrick Garland, a very qualified judge, was not even considered by the Senate because the Senate wanted to preserve the possibility of a Republican president controlling the presidency. And of course, they succeeded in preventing Merrick Garland from joining the court, and instead Neil Gorsuch assumed that seat. That action by the Republican senators has prompted a counter-reaction. So many Democrats have now called for court packing, for legislation that would enable the next Democratic president to appoint more Supreme Court justices, to turn the balance back to the Democratic Party. At one time, this would have been unimaginable, not serious. But as of now, 6 of the candidates for president, for the nomination of the Democratic Party for president, have endorsed court packing. And the former Attorney General of the United States, Eric Holder, the Attorney General under President Obama, has endorsed court packing. No one should believe that if there is court packing by Democrats when they regain the presidency, that the Republicans would not retaliate. And in fact, some commentators have suggested that therefore you ought to pack the court to the maximum the first time you get the opportunity. The Democrats should expand the size of our Supreme Court to more than 50 justices, on the theory that if you had more than 50 justices, there's no room in the Supreme Court building for more. And so you've reached the maximum capacity. I think that in Argentina, you have experience of court packing, that you have experienced how politicization of the court can lead to this eventuality. Please do not tell your colleagues in the United States about the other technique that has been used in Argentina, the impeachment of all of the justices of the Supreme Court, right? If we have court packing and the mechanism of impeachment is used so that the political parties control the composition of the court, then I think things become very dangerous indeed. The second justification for the constraint principle is founded on the political value of legitimacy. Legitimacy is a multi-dimensional concept, and there are at least two aspects of legitimacy that are implicated by the constraint principle. The first aspect of legitimacy is democratic legitimacy. So our Constitution was approved by an intensely democratic political process with popular participation. It was a flawed process. Many groups were excluded, and so it does not have perfect democratic legitimacy. Amendments to our Constitution must be approved by a supermajority, by 2/3 of the House, 2/3 of the Senate, and 3/4 of the state legislatures. Again, a democratic political process. The alternative, to turn the Constitution over to the Supreme Court, to allow the Supreme Court to violate the constraint principle and create doctrines of constitutional law that are inconsistent with the constitutional text, is profoundly anti-democratic. Our Constitution consists of only 9 persons. Your Supreme Court has 5 members. In the American context, this means that 5 individuals can change the Constitution. They are unelected. They serve for life terms. In the context of Argentina, 3 individuals would have that power. Constitution making by a committee of 9 with a majority vote of 5 is less democratic than is the process of constitutional amendment through supermajorities. Neither process is perfectly democratic, but of the 2 processes, sticking with the constitutional text has the greater democratic legitimacy. A second aspect of legitimacy concerns transparency, the ability of citizens and others to know why constitutional law is being made. What are the underlying bases, the reasons, the motives on the basis of which constitutional decisions are made by the court? The constraint principle requires the court to follow the constitutional text. The basis for the decision is apparent on the surface of constitutional decisions. The alternative, living constitutionalism, encourages judges to conceal the true basis for their decision in two ways. First, to the extent that the justices, in fact, are deciding on the basis of their political values or their moral beliefs, they do not state that on the surface of their opinions. They disguise the true basis for the decision with legal arguments that are actually window dressing. They are actually reasons that cover the underlying actual reasons for the decision. And secondly, living constitutionalist courts are very rarely willing to admit clearly that they are overriding the constitutional text. So our court, on many occasions, has made decisions that have the effect of nullifying or changing provisions of the constitutional text. But they almost never say this. They almost always come up with rationalizations and obfuscations that disguise the way in which they alter the text. The third idea. So the first idea is fixation. The second idea is the constraint principle. The third idea is the public meaning thesis. The public meaning thesis is the claim that the original meaning of the constitutional text was its meaning for the public, the ordinary meaning of the text. And in the case of the United States Constitution, there are three reasons to believe that the meaning is the public meaning. First, the constitutional text itself announces that it is a public document. The United States Constitution begins, "We the people." The United States Constitution enshrines the idea of a republican form of government. It is a constitution that is a res publica, a public thing. Second, the process of ratification of the United States Constitution was intensely public. Our ratification process involved meetings in cities and towns and villages throughout the United States. In these meetings, ordinary citizens came together and read the Constitution. The Constitution was read out loud, its provisions were debated and discussed, and then at these local meetings, representatives were elected to the ratifying conventions that then adopted the constitutional text. So the ratification process presumed that ordinary citizens could understand the constitutional text. Third, early commentators, when they discussed the meaning of the Constitution, over and over again stated that the Constitution should be understood to have its ordinary meaning because the Constitution was written for the public and was intended to be ratified by a public process. So, for example, Chief Justice John Marshall, the great early Chief Justice of the United States Supreme Court, said this in multiple opinions. Justice Story, the author of the great commentaries on the Constitution of the United States, made this point explicitly. Early opinions about constitutional interpretation are full of statements that it is a public document. And there are very few statements that suggest otherwise. Now, the case of the Constitution of Argentina is not identical. The Constitution of Argentina was not ratified by a similar process. In 1853, there was a constitutional convention. You know more about this. That Constitution, though, was not written exclusively by lawyers. it was written by a diverse group of Argentine citizens, including citizens who were educated, but not necessarily legal specialists. Likewise, the Constitution of Argentina was written to be implemented. Now, part of the audience of the constitutional text, the intended readership, would have been the courts, the judges of the Supreme Court. But the Constitution would have been implemented also by the President, by executive officials, and by the members of Congress. So the meaning of the Argentine Constitution would not necessarily be a specialized legal meaning, although I am not sure whether that meaning would be identical to public meaning. Certainly in the Argentine Constitution itself and in the Constitutional Convention, there were references to the public. And I understand that sort of the concluding remarks at the Constitutional Convention include references to the public. So there's a question in my mind as to exactly how the Argentine Constitution would relate to the public meaning thesis. So in addition to those three ideas, fixation, constraint, and public meaning, I'd like to introduce one more technical distinction, just so that it is on the table. So in American legal theory, we distinguish between interpretation and construction. Now this is a technical distinction. You don't have to label the distinction using these words. But here's what the distinction is. Interpretation refers to the process of determining the meaning of the text. What does the text say? What content did the text communicate? Construction refers to the process of determining the legal effect to be given to the text. One kind of legal effect is the construction of constitutional rules or doctrines, implementing rules. Precisification, rules that allow the abstract text to be put in legal effect, into legal effect. Another kind of legal effect is the decision of concrete cases. So originalists believe that interpretation must constrain construction. Living constitutionalists believe that construction need not be constrained by interpretation, that constitutional construction is not required to conform to constitutional interpretation. Finally, let me give two examples. One, an example from the United States, and one, an example from Argentina. So here is my example from the United States. It is a famous Supreme Court case, the case of Wickard versus Filburn. This case was decided in the 1940s, and it concerned a law passed by Congress. Under the United States Constitution, Congress has limited and enumerated powers. The greatest of these powers, the most expansive of these powers, is the power to regulate commerce among the several states, or interstate commerce. Congress passed a statute, the Agricultural Adjustment Act. This statute regulated the amount of wheat that a farmer could grow on his own farm for his own consumption. So, first of all, the growing of wheat is not commerce. The word commerce was understood in 1787 and in the decisions of the Supreme Court up until cases like Wickard v. Filburn to refer to trade in goods. And agriculture was clearly understood as not commerce. A distinction was made between trade versus agriculture. And consuming wheat on your own farm is not an interstate activity, unless your farm is right on the boundary between two states and you grow the wheat on one side of the boundary and consume it on the other side. A very rare event. The Supreme Court now had to decide what to do about this provision of the Agricultural Adjustment Act. And in their deliberations, we know this because the papers of the justices are now public, so we know what they said to each other. In their deliberations, the justices said, you know, we've got a real problem here. This statute appears to be unconstitutional. But these justices were New Dealers. They had been appointed, all but one of them had been appointed by Franklin Delano Roosevelt, who actually required all judges to have a conversation with him in which they would indicate their loyalty to the New Deal. So for them, the idea of striking down this legislation was not an option. Their whole reason to be on the court was to uphold New Deal legislation. So they discussed what they should do, and the first thing they discussed was the possibility that they would end judicial review, that they would no longer review the statutes enacted by Congress for constitutionality. But when they discussed this possibility, they became concerned that ending the practice of judicial review would have serious consequences for the Supreme Court and for the Roosevelt administration, that this would be viewed as a very radical step. So they did not do that. Instead, they adopted a living constitutionalist interpretation, a doctrinal device that went as follows. A government action is within the Commerce Clause power if it has any significant effect, any significant consequence for interstate commerce. And this is not a factual question. No evidence need be introduced on this question. Instead, we will use, you may be familiar with this term, rational basis review. So in the United States, rational basis review means, in this context, that if a rational Congress, that means a Congress that's not crazy, it's not insane, it's not bonkers, it does not belong in some kind of a mental institution. If a rational Congress could imaginably have believed that there was a significant effect on interstate commerce, then the regulation is permitted. Under this standard, the Commerce Clause no longer limits federal power. Every possible regulation will be upheld because almost anything Congress can do can imaginably have a significant effect on interstate commerce. In fact, that is the way I was taught the Commerce Clause when I was a law student, that the Commerce Clause authorizes almost all conceivable congressional legislation. Originalists say that was a mistake. That if we wanted to expand the powers of Congress, we should have amended the Constitution, not interpreted the Commerce Clause out of existence. Second example. This is an example from Argentina. So I am not teaching you, you were teaching me. In Argentina and in other nations as well, there is a form of living constitutionalism that relies on extra-national sources of constitutional law. So in the case of South Africa, this approach is an originalist approach, because the South African Constitution has a clause that specifically says that comparative law will be considered in the interpretation of the South African Constitution. So, in the context of Latin America, we have the American Convention on Human Rights and the decisions of the Inter-American Court of Human Rights. So there are two ways in which an originalist could be concerned about the use of the decisions of the Inter-American Court. First, we might be concerned about the use of those decisions when it would be inconsistent with the Constitution of Argentina. An originalist would want to use the decisions of the tribunal to alter constitutional provisions of the Constitution of Argentina only if the Constitution of Argentina permitted that. So that would be a question, and we would look to the original meaning of the Constitution of Argentina. Second, of course, the convention, the American Convention on Human Rights, is also to be interpreted. And an originalist would want to be a convention originalist, to interpret the convention in accord with its original meaning, and would be concerned about living conventionalism, the approach to the convention that would allow the Inter-American Court of Human Rights to develop doctrines that are inconsistent with or not fairly traceable to the convention itself. So now I know really very little. I only know a tiny little bit about this issue, but I'm very interested in the issue, and so I'm interested in how this issue would be approached from the perspective of students of the Constitution of Argentina. I will stop there. Thank you very much.
Presentando sus textos. Yo voy a hacer una breve introducción, resumen en castellano, y luego voy a pasar al inglés. Además, viendo que la gran mayoría de ustedes entiende el inglés, y así simplemente para facilitar la comunicación. Lo que voy a hacer es un poco el camino inverso de lo que él ha hecho. Voy a mostrar primero por qué el originalismo es implausible, aún en la versión del Public Meaning Originalism, y voy a defender luego, hacia el final, una alternativa a la que voy a llamar alternativa de la conversación democrática. Los problemas que yo veo en el originalismo y que hacen que, en mi opinión, se convierta en una teoría interpretativa insostenible, tiene que ver con que es muy difícil tomárselo en serio, porque es difícil determinar qué es lo que dice el originalismo, qué es lo que pide, qué es lo que nos exige, qué es lo que nos pide, y que eso afecta, o sea, esa imposibilidad afecta también su justificación, en particular en los que yo entiendo, y parte lo ha dicho ya el profesor, son algunas de las principales razones a favor del originalismo. Uno, su capacidad para dar certeza contra la discrecionalidad que hable el living constitucionalismo, el constitucionalismo viviente. Y dos, razones democráticas, que tienen que ver con razones de la legitimidad democrática. Creo que el originalismo, por su grado de indeterminación, no nos da ni certeza ni nos permite, digamos, afirmarnos en esas razones democráticas. Finalmente diré que el tipo de originalismo que defiende el profesor digamos, choca con nuestras convicciones básicas en materia democrática y choca también con nuestras convicciones básicas en términos de organización en comunidad, en una comunidad de iguales, porque hace dependiente la defensa de ciertas minorías y ciertos derechos de unas búsquedas históricas imposibles finalmente de darnos una respuesta cierta. O sea que deja pendiente la defensa de los derechos, los casos más graves, en cuestiones, yo diría, básicamente irrelevantes, en cuestiones, además de digamos, menores, cuestiones muy difíciles de determinar. Entonces, voy a contrastar esa visión del originalismo con lo que yo llamo una alternativa de la comunidad de iguales, el diálogo en una comunidad de iguales, y voy a ilustrarlo con dos casos recientes en Argentina. Uno es el de la discusión de la ley de medios y otro es la discusión sobre la ley de aborto. Bueno, paso al inglés. Disculpen entonces para los que tienen más dificultades con el inglés. My presentation will have two parts. One will be a criticism of originalism, trying to say that originalism is untenable. It's very difficult to take originalism seriously because it's very difficult to define what the requirements of originalism are, so what to do in order to be a good originalist. And then I would say that affects the justification of originalism, and particularly affects what I take to be the two main reasons in favor of originalism, which are its capacity to give us certainty against the discretion that will be typical in a living constitutionalism world. And second, it also affects its promise to honor democracy. And then I will end by presenting an alternative, if I have some minutes, which I call the alternative of interpretation as a democratic conversation in a community of equals. And I will illustrate this abstract approach, which of course, I mean, it's in the family, I would say, of living constitutionalism, but also I would say it differs significantly with regard to some of the basics of living constitutionalism. And I will illustrate this with two cases which have been extremely important in Argentina public life recently. One is the discussion of the abortion case, and second is the discussion of the media law. Well, so about the impossibilities of originalism. I may begin with a quote by Jacques Maritain that you may know. So he was interviewed after his participation in the drafting of the Human Rights Declaration. And he said, well, I mean, the question was, well, how you manage, I mean, with all these different people, different countries, different contexts, to put together a common declaration? And he said, well, basically, we agree on the basis that nobody asked us how we agree, because, I mean, the disagreement was complete, but well, we got that. And so nobody should ask us about, and that I take that is a common story of documents that are written by people who greatly differ in their basic viewpoints. So that basically, I mean, the materials that we have are very difficult to define and extract a clear meaning. But then, in terms of the certainty which is promised by originalism, I would say that even if originalism could give us certainty, I would reject originalism for different reasons, which are democratic reasons. But the promise of certainty is, of course, a promise that is important if we care about the rule of law, if we care about stability, etc. But so, I would say that neither the traditional version of originalism, so connected to the intentions of the framers, nor public meaning originalism can provide that certainty. The problems of originalism of intention, we know, you describe them, and are more or less well understood, I think, by all. I mean, the extreme difficulty of recognizing what these people have in mind. These people are also very different, and so there are many reasons that complicate the search of intentions. But what about the search of public meaning? Take, I mean, some of your texts. I take at least the two texts that you sent us. So in different parts of your work, I mean, and I take you or Scalia are symbols of public meaning originalism. So you recommend us to do some historical research, to read articles by legal academics. You quote many of them, and you take the words of some of these authors. So, for example, discovering the real meaning of, or the most common meaning, understanding of the word unusual in cruel and unusual punishment. And sometimes you also say that we should study philosophy of language or do linguistics, and then you quote corpus linguistics, and then the big data semantic, and then the theories and empirical methods of linguistic science. Well, I mean, all those are extremely important instruments to try to understand what the law said at one point, but that makes our task extremely complicated, and it's not just a matter of complication, it's that then we have extreme disagreements about how to rank the difference that we are going to find between what the corpus linguistics says and what the history says, and then, of course, I mean, what legal academics said in different articles. So I was asking you before in another event we have about the school desegregation problem, so the Brown versus Board of Education case. Well, and so there is, and you recognize, a kind of common understanding, I mean, inside the legal community, that public meaning originalism was consistent with desegregation, with segregation, racial segregation at school. Well, then you say, no, of course, that article which made that point so forcefully and became so influential article, the Richard Fallon article, well, that's wrong. He said, no, one argument. You said, so there is nada, not one, nil, zero, sí. Well, but that's not an argument, and that's not important because I take it as in a way, as a joke. But the fact is, it reflects the kind of problem we face, is that it may be that within the legal academia there is an agreement about something, for example, an agreement that most academics understand that public meaning originalism was consistent with racial segregation, and then you say, in this case, without giving an argument, no, that is not true. Well, but that's the kind of problem that we always going to find, and then it's not only that we are going to have to compare good academic articles written within the legal community, but also we have to resort to the big data and to linguistics and to the philosophy of language. So this is an extremely complex, which doesn't promise to give us a good ending, because it's not that, well, at the end of this great historical research, this extremely difficult historical research, finally we will get the answer. No, finally we will get a disagreement. So even if we go all that way, then at the end we get a disagreement, and you may say to Richard Fallon's famous article, nothing, see, nothing. So that's the kind of things we are facing when we go all the way down through the originalist public meaning path. But then the question is, even if we got that, then it would be, I would say, kind of offensive for a legal community to say, and I think as many or some public meaning originalists would say, that we have to change our views about, say, mass incarceration or death penalty or segregation because of, finally, this author, say, John Stineford, found that cruel and unusual punishment is not consistent or is consistent with death penalty or is not consistent with mass incarceration. Well, it's offensive to, I would say, to a democratic community to say that we are going to solve our deep disagreement about these kind of issues regarding which the Constitution says nothing, because the Constitution says nothing about death penalty, it says nothing about mass incarceration, says nothing about segregation, and we are going to solve in this way rather than discussing between equals. So first, it's extremely difficult to find a good answer or a definite answer or an answer that we have conclusive reasons to agree. And second, even in the magic case, in the extraordinary case that we get that answer, well, that would be problematic for a community to decide that way the main profound conflicts they have concerning how to organize themselves. Just a few more notes about my critique to originalism. I think that all the efforts made by public meaning originalists like Scalia or you, in order to make it originalism more attractive, well, make it more attractive or less counterintuitive at the cost of emptying the content of originalism. So at the end, you don't know exactly what's the meaning of originalism, because it's a fixed meaning, but then the fixed meaning changes because it may say press, but well, it comes internet and internet is included. But it's not that the meaning was fixed. Well, no. Then we have those abstract clauses, and we are going to take those into account. Then we have the issue of disagreement, and we are going to take that into account. Then we have the issue of intention. Should we take, I mean, it seems that public meaning originalism was born in a reaction against intentions, but then we find cases like Smith case, no? The case of the gunfire. So there was this famous case of a drug crime, and then in the law it says that if in the drug crime it was a gun involved, then the punishment was going to be higher. Then this guy exchanged drug for a gun, and then they say, okay, then Scalia said, no, of course, this is a very wrong decision. It's totally badly decided, because in the end, the intention was to use the word gun in the sense of menacing someone and not an exchange for drugs. So again, as Dworkin said in his critique toward Scalia, so finally, you want to reject intention, but the intentions are there and comes to be present. So it's fixed, but it's not fixed. It's definite, but it's not definite. Intentions are not there, but then are there. So it becomes very difficult to define. When I was reading your article, I was asking, what is exactly public meaning originalism? What the framer thought, or what how we understand the world today. Well, then I got your article. So one title in your article is The Right Question, thought to those. What is the public meaning of the constitutional text? The next line, here is the right question. What was the public meaning of the constitutional text? Well, is or is was. And of course, this is anecdotal. You may say, well, you wanted to say both things, but it becomes very difficult for someone who is not sympathetic to originalism to understand what public meaning originalism are asking us. And as I said, I mean, in the best case, they promise a research that doesn't give us a definite answer, and if we get that definite answer, then I would say we have reason to reject. And the main reasons, I would say, and this before turning to my proposal, the main reason to reject, I mean, first, having made it clear that for me it's extremely difficult to get a definite answer or non-disputable answer from historical research or linguistic research. But the final question is a democratic question. And that's why also I asked you this afternoon about what's your view about democracy. Because now you were saying, we care about with the people, and we care about the ratification process. Well, but I mean, so this is because you care about democracy, but how you understand democracy? Democracy is something that a lot of people said in the past, and what about our agreements today? That's one thing. The other is, if the answer about our conflicts and disagreements are going to be found in corpus linguistics, or as scientific research, or in philosophers of language, well, what about democracy, as I said? Because what about me? As I said, if the problem of mass incarceration or the problem of racial disaggregation we are going to solve asking to the definite answer to the philosophy of language people, well, I mean, and what about democracy? So these are not substantive issues that we should decide in a conversation. And so I turn to my own proposal. In my understanding is we have to take, my basic assumption is that we are all equals in our moral dignity, that we are all participants in a democratic community, and that we have to discuss together about the common problems we face. And the Constitution, what does is to establish the framework to organize that conversation, organize that discussion. Of course, we may have disagreements about those rules, but even if in that case we have to discuss about how to understand those rules. So one example. 5 minutes ago, 6 minutes. In a community of equals, imagine that we move to the countryside and we organize our community of equals. Well, then we may say, well, in this community of equals, we want to organize ourselves in a different way. We want to treat each other with equal consideration and respect. And basically, here we are going to work together and do things together. So maybe we write just one rule on the wall and we say, everybody, all adults are going to work in the land, since they are adults. Then one day it comes Maria, and Maria cannot work because she's ill, and say, oh, but I'm concerned about what we wrote in the wall. And no problem at all. We discuss about that. Of course, you are ill and you are not going to work. That doesn't count. And then it comes Pedro, who turned from 17 years old to 18, and he say, oh, I have asthma. I cannot go to the countryside to work in the land. Can I stay home? And then we get together and say, of course you can. Well, but this is how in a democratic community we have to solve the problems about the rules we have. Is we sit together and we discuss in good faith the meaning of the rules we establish for ourselves. Even if the community is bigger and we choose a few people, to take care of the conflicts we have, well, those people would shock us if in order to understand the rule they take the dictionary or they make an historical research. But of course not. In a democratic community, you are supposed to decide things according to what we conceive of together about this problem. So a very quick turn to these cases in Argentina. In the recent years, in the last, I would say 5 years, we have at least 2 incredible collective discussions. It's not that I agree with the results and I don't care about, in a way, the results, but what is true is that we have 2 spectacular instances of public deliberation. So deliberation in the court, deliberation outside the court, deliberation in Congress, deliberation in the streets, so around these issues. One was the media law and the other was the abortion law. Well, for me, those cases were extraordinary because they show that we may have disagreements about problems that one, understandable interpretation of the Constitution, one could have said, no, the Constitution says something about those issues when they say something about the press or say something about the freedom of expression, or say something when it says about abortion, when it says life, or when it says dignity, etc. Well, but we disagree about those issues, and I think that in a democratic community, what we have to do is, in a way, start the discussion that we started in those cases. Again, I think that there were many imperfections in how those discussions were carried out. But the interesting thing is that those were, for me, fundamental valorative issues that we had to discuss, and we took the opportunity to discuss that together, and I think that was the right way to proceed. Again, I would complain about the details of how those debates develop, but I think that those instances give us an idea that crucial constitutional problems can and should be, in a community of equals, can and should be discussed by all together, and that is not an impossibility, that is not utopian, that is not silly, and I think that is much more interesting, that deciding basic constitutional problems is not your suggestion, but by going to the dictionary, or by going to big data, or by going to an article by this or that other author, that's not the way in a democratic community. We have to sit together and try to, to solve our basic disagreements. So my presentation, I wanted to do, in a way, the opposite of what you were doing. First, suggesting the implausibility of originalism, and second, suggesting that there are alternatives available that doesn't take us to what you said as a James Tyler alternative, which is to give judges a final authority. No. Judges participate in that discussion, but they don't have the final authority. So it's not that we need to depend on good democratic judges or whatever. No, it's something that the community should discuss about those issues, and it's not that we have to rely on the expertise of scientific, linguistic, or judges. It's something to be discussed collectively. So that will be all. Thank you.
Okay, very good.
Le doy la palabra 10-15 minutos al profesor Solum para que le responda al profesor Gargarella, y después lo que nos quede de tiempo hasta las 20:15 continuaremos. Profesor Solum.
So thank you for those very illuminating and helpful remarks. So let me begin by discussing the problem of certainty. And I think we first need to divide this problem into two parts. So when we're thinking about the original meaning of the United States Constitution, with which I'm very familiar, and about the meaning of the Constitution of Argentina, with which I'm less familiar, it's important to recognize that most of the constitutional text has a very clear original meaning. So, for example, the most important provisions of the United States Constitution are the basic structural provisions. It establishes a Senate and a House of Representatives, provides that each state has 2 senators, and that the House of Representatives is apportioned according to population. It requires that legislation pass both the House and the Senate and then be presented to the President for veto, and if there is a veto, that the override must be by 2/3 of each House of Congress. It establishes the Supreme Court as an institution, and so on. We call this sometimes the hard-wired Constitution, the parts of the Constitution that establish basic structures. And by far, this is the most important part of the Constitution. And following the meaning of these parts of the Constitution does not require the resolution of arcane historical debates. These parts of the Constitution are clear. So now, it's possible that we could do things differently. it's possible that we could get everyone together, and every time the House of Representatives is elected, we could discuss the question how the House of Representatives will be apportioned. Or we could discuss, are we going to change from an individual president to one of the propositions that was advanced at the convention, a plural presidency, a committee of 3 presidents. We could discuss this every time. But this, it seems to me, is a manifestly impractical way of settling questions of basic structure. We need to have a framework, and the most important role of originalism is ensuring that the Supreme Court does not alter that basic framework. Now, you may say that will never happen, but of course in the United States it has happened in a variety of ways, large and small, right? So the Supreme Court, for example, has allowed Congress to pass legislation giving legislative power to private groups. Private groups are authorized to enact statutes that bind everyone participating in a given industry, for example. This is a clear violation of the most fundamental principles of separation of power. So this is the easy cases. What about the hard cases? So there are hard cases. There's no question about that. I want to say, though, first of all, that not all of the cases that you might think are hard, based on armchair speculation and reading the decisions of the United States Supreme Court, are in fact that difficult. Many constitutional provisions have a fairly clear meaning that historians and legal researchers can agree on with relative ease, even though the modern interpretation might be quite different. And an example of this is the Equal Protection Clause. So the Equal Protection Clause of the United States Constitution is interpreted now to create some general principle of moral equality. But the original meaning was quite different. The word equal did not even appear in the clause until late in the drafting process. This clause was about the protection of the laws. The history is clear on this, that the purpose of the clause was to enable Congress to provide federal laws that protected the former slaves from violence and from theft, to make sure that they were protected by the general laws. And if the states did not do this, Congress was authorized to step in. So this is a provision that you might think, well, this is, infinitely debatable, but actually the historical record, I think, is relatively clear. I want to just say one thing about the debate about Brown versus Board of Education. So there is, Richard Fallon is not the appropriate target here. My friend Richard Fallon, I was quoting a passage where he says that historians have established that Brown v. Board was inconsistent with original meaning. And he was referring to an article, a very famous article by a historian, Michael Klarman. And the passage that was read, which was not, I think, from the paper I circulated today, but from another paper, Surprising Originalism, was discussing the fact that this article by Michael Klarman, it's a very interesting article, but it in no way addresses public meaning originalism. The article is supposedly talking about the original, the article is represented by others as talking about the original meaning of Section 1 of the 14th Amendment. Well, the clause that's relevant here, the Privileges or Immunities Clause, was not even mentioned in this article. In fact, no provision of the constitutional text was analyzed by this article. What the article was talking about was public opinion about segregation in 1865 through 1868. Well, that's very interesting. That's something that historians certainly want to know about. But this article, which is sometimes represented as establishing that Brown v. Board was wrong as a matter of original meaning, it just does not even address the question. And it really was unlikely that it would have addressed the question because it was written by an author who was entirely unfamiliar with what originalism actually said. Let me talk a little bit about the alternative view that is presented here. So the alternative view that's presented here is the idea of a democratic conversation among equals. So I want to say that this idea, right, there are various ways of presenting this idea. In American political theory, it's strongly associated with the idea of a deliberative democracy, right? A democratic conversation, a democracy that deliberates. So now, ask yourself the question, how can we have a deliberative democracy? Is the best way to implement a deliberative democracy to give to the justices of the Supreme Court the power to adopt constitutional amendments? And it seems obvious that the answer to this question is no. In order for deliberative democracy to take place, at a minimum, we need to have the Supreme Court follow the constitutional text and maintain the framework for democracy established by that text. Now, it's true. There are provisions of the Constitution that address important questions. There's no question about that. And I think that some of these provisions may, in fact, resolve important questions. It's possible, for example, that the cruel and unusual punishment clause of the United States Constitution is not consistent with the practices of mass incarceration and sort of infinite sentences for minor crimes. And that a democratic conversation might yield a different result, right? That a democratic conversation might resolve this issue differently. But then we reach the question, how should that be done? If we want to change our constitutional norms, we always have the option of constitutional amendment. Constitutional amendments are difficult, but if it is in fact the case that we are able to reach consensus and agreement as a democratic society, then we can express that consensus or agreement via constitutional amendment. Now, I want to point out, however, a problem with the idea of consensus-driven democratic politics in modern pluralistic societies, and this is the problem of pluralism. So I can't speak to Argentina. I don't know the situation in Argentina, but in the United States, it is clear that we have a very pluralistic society characterized by political polarization. And so democratic conversation leading to consensus is just not an option on many questions. I would like for our politics to change, but you have to have a constitution that can cope with the reality that on many questions there is not an agreement, but there is a need for legal settlement. There must be some solution to these great problems, and a constitutional text creates a baseline settlement against which democratic conversation can take place. Now, I just want to end with one more point. It's absolutely true that in hard cases, it may be necessary to do historical research. It might be necessary to resort to sort of scientific investigation of the meaning of the words at the time a constitutional provision was written, right? But that does not mean that there is no process for settling such disputes. Courts are well aware of the idea that when there is disagreement, you must in the end go with the preponderance of evidence, with the better case. And so disputes about the meaning, the original meaning of the Constitution will be settled in the same way that other disputes are settled through a judicial process, and that is that the stronger argument will prevail. Is originalism perfect? Surely not. Surely not. But as Justice Scalia said, it may well be better than all of the alternatives.
Tenemos 20 minutos más de intérprete. ¿Correcto, intérprete? Hasta las 20:15. Gracias. Así que, bien, voy a tomar varias preguntas, me parece 3 preguntas, y le damos la palabra al profesor Solum. ¿Vas a preguntar en inglés o en castellano? En inglés. ¿Vos, Pedro? En inglés. ¿Y acá? En inglés. Bueno, si pueden acercarse, así lo hacen por el micrófono. No, claro, porque hay otros que están escuchando a través del audífono. Bien. Te pido tu nombre y la universidad, por favor.
Yo soy Wickard de la Universidad de San Andrés. Mine is more a comment. I'm conceding. Mine is more a comment to the critique, and I would like to know your views about it. I believe that the critique is not against originalism, but against the Constitution as the supreme law of the land, and against judicial review. Because if you take the decision of having a Constitution as the supreme law of the land, and that Constitution is not subject to permanent amendment by the same procedure that you use to enact laws, then there must be a limit. Not everything is subject to democratic debate. Basically, the Constitution takes lots of things out of democratic debate. They are not subject to debate because they have been fixed in the Constitution, and if you want to change that, you have to change the Constitution. Thank you.
Pedro, por favor.
I have 2 questions. The first one concerns, I think that there is a problem between the constraint or restraint thesis and the public meaning thesis. If the restraint thesis requires that there is some public meaning in order to restrain judicial decision, then if we have a current or contemporary public meaning, then this contemporary public meaning, if it is public, it will constrain judicial decision as well. So why is it that the restraint thesis requires originalism? And the second question is, in order, if we have time, to develop the distinction between interpretation and construction. My question is it the same distinction as, for example, Richard Fallon's distinction between interpretation and implementation of the Constitution? And if it is the same distinction, or if it is similar enough, then would some construction doctrines allow for the under-enforcement of the constitutional clauses interpreted in an originalist way?
Gracias, Pedro Caminos. ¿El próximo? nombre y universidad de referencia.
Francisco Gibson, Universidad de Buenos Aires. So this is a question about those few cases where the constitutional meaning is actually determined, if there are such cases. So my question is, how should Supreme Justices decide what should they do in those cases according to originalism? So if we take the value of the rule of law, it is not clear what they should do because there is no such thing as a determined answer to what the law is. If we take the value of democratic legitimacy, well, we want to avoid judges becoming super legislators, so we should perhaps give them the power to decide such cases. Should they just say, abstain from deciding?
Professor Solum?
Okay, yes, thank you. Those are all very good questions. Let me take them in reverse order. So the last question concerns the possibility that the meaning of a constitutional provision is indeterminate. In answering this question, I want to distinguish between true indeterminacy and what I want to call underdeterminacy. So if a constitutional provision were truly indeterminate, that is, it has no meaning, it doesn't communicate any content, then that provision should not be given legal effect because it doesn't say anything. And it certainly should not be taken as a license for judges to simply make something up. I don't think that in the case of the United States Constitution there are any provisions that are indeterminate, radically indeterminate, that communicate nothing. The actual problem in the real world is underdeterminacy. So an underdeterminate constitutional provision permits some resolutions of issues or cases, but rules others out. Underdeterminacy can be produced in a number of ways. For example, the constitutional text may employ a term that is vague or open-textured in HLA hard sense. So this would then create a zone of possible implementations, right? And in my writing, I call this the construction zone, right? Interpretation yields an underdeterminate meaning. We then need to fill in or precisify or implement with a constitutional construction. So how should you do constitutional construction in those cases? So this requires a theory of constitutional construction, and I'm still working on this problem. It's a big and important problem, but here's my tentative view. Step one, we determine the function or purpose of the provision to the extent that that function or purpose can be ascertained. And we now, in good faith, judges acting in good faith, should adopt an implementing rule or precisification that is consistent with the function or purpose of the provision. But, of course, there may be more than one implementing rule that would be consistent with what we know about the purpose of the provision. In that case, we should adopt rules that are maximally consistent with existing law and that achieve the purpose. And so at this second stage, we would consider, for example, judicial precedent and the historical practice of Congress, the President, the states, etc., and we would adopt that implementing rule or that precisification that involves the smallest departure from the existing law. Step three, this may still not resolve the case. If the underdeterminacy remains, then we ought to adopt the solution that is consistent with decisions taken by the democratic branches. and this rule requires us to establish a hierarchy, so I would say we would first defer to decisions made by Congress through legislation. Then we would defer to decisions made by the elected national executive, by the president, or by persons who report to the president, and then in a similar way to decisions made by democratic processes at the state level. So we have a system of construction to resolve underdeterminisms. Let me move to the second question. So I'm not sure I understand the first of the two questions. This was a question about the relationship of the constraint principle. A question about the relationship of the constraint principle and the public meaning thesis. So the fixation thesis says that the relevant public meaning is the original public meaning, the meaning communicated by the text to the public at the time the provision was adopted, not the meaning of the text as it would be interpreted had it been written today, the fictional meaning that the text would have if we assumed it was written today. So I may misunderstand the question, but I see no tension between the constraint thesis and the public meaning thesis. The interpretation construction distinction and its relationship to Richard Fallon's distinction between interpretation and implementation. So what Fallon calls implementation rules are in fact constructions. And what he calls interpretation, as I understand it, involves both what I call interpretation and what I call construction. Now, I gotta just ask you to take my word for this, because to do otherwise would require a detailed exposition of Fallon's theorization of interpretation, and it's not worth our time to spend the time figuring out exactly what Fallon meant. The first question regarding not my presentation, but about the critique. I agree with in part and disagree with in part. So here's the part I agree with. Much criticism of originalism turns out to be a criticism of the idea of an enforced written constitution. If you accept the thesis and you nonetheless object to the idea that we're going to enforce the Constitution, then it may very well be that your complaint is with the idea of a written constitution and not with the idea of originalism per se. Here's what I disagree with about the remark. It seems to me that it is important to realize that some forms of living constitutionalism are concerned with fidelity to the text. So there are living constitutionalists who believe in fidelity to the text, but believe that fidelity to the text is best expressed not in fidelity to the meaning of the text, but to something else. So, for example, Dworkinians, moral reading theorists, they believe in a kind of fidelity to the text, not to the meaning of the text in the sense in which I identify meaning, but to the moral reading of the text. And they think that's the best way to express fidelity. So Dworkin doesn't want to do away with the Constitution. In fact, he strongly believes that Hercules, his ideal judge, should pay serious attention to the Constitution, its structure, to the decisions of the Supreme Court, and to other elements of our constitutional history. So I don't want to engage in oversimplification, right? There can be competing ideas of fidelity, and to the extent that I disagree with Dworkin, then we have to argue about whether the moral readings approach offers a defensible ideal of fidelity. I think it does not, but I would concede, in fact I would insist, that Dworkin does believe that his theory expresses a defensible idea of fidelity.
Bueno, ya tenemos que terminar. Quiero agradecer a Pedro Camino. You can take the hearing. Quiero agradecer a Pedro Caminos y le voy a dar por la organización y le voy a dar la palabra para que cierre el evento el presidente de la Asociación Argentina de Filosofía del Derecho, el profesor Renato.
Buenas noches, gracias profesor Juan Pablo Alonso. Buenas noches a todos ustedes, gracias por acompañarnos. Profesor Gargarela, gracias por acudir a nuestro convite. Profesor Solum, un placer, pleasure, it's an honor to have you here for us. We hope that it's not going to be the last time. And, bueno, me parece que a lo largo de todas estas sesiones han aparecido innumerables temas, modelos de jueces, modelos de casos, textos, pretextos, contextos, fidelidades al texto desde una perspectiva literalista, desde una perspectiva de la Constitution, es decir, tensiones, armonizaciones que nos invitan a seguir pensando. Aquí hemos tratado cuestiones muy constitucionales, muy filosóficas, y me parece que la clave está en ese puente de invitarnos y desafiarnos a seguir pensando y repensando hasta el fin las cosas, como alguna vez yo gusta hablar. Muchas gracias por acompañarnos. Thank you again, Mr. Solum. You have to know that this is also your house. Buenas noches.